Hi, my name is Andrew. Today I'm here to teach real property for the Florida bar exam. Real property is understood to be the most difficult subject on the Florida bar exam, but hopefully I'll make it easy today. When we think about real property, we have to understand that it's essentially a contracts essay, but dealing with the specifically land sale. So real property contracts need to be in writing under the statute of frauds, and the sale of land needs to adequately describe the property, it needs to describe the parties, and like we said, it needs to be in writing. Now, if a deed is actually delivered, it needs to conform with deed formalities, which means that it's attested to by two witnesses, and like we said, has the adequate formalities of being in writing and adequately describing the property and the parties. So deed formalities and the fact that real property contracts need to be in writing are two key points to start an essay off with if we're dealing with real property. And then there's a lot of directions we could go. It's important to understand that a deed is one way to have title to property, but it's not the only way, right? You could also acquire title via adverse possession. And adverse possession is when you acquire property pretty much by being a squatter. It has to be open, continuous, exclusive, adverse, notorious, and hostile for the statutory period, which is 7 years in Florida. So you can have title via adverse possession, or you can have title via deed, and via deed is the best way. But let's step back into the adverse possession thing. In Florida, you could have adverse possession with color of title or without color of title. And it's important to distinguish what color of title means. Color of title means appearance of title. So you may have a defective deed. You have some document that purports title, but you don't actually have title. If you have with color of title or without color of title and you're making an adverse possession claim, you always have to have made some enclosure on the property. Maybe you fenced it in or something like that. And this is important to look out for in an essay. If you see some fence enclosure, it's probably pointing you to an adverse possession discussion. Now, if you are claiming with color of title, which means you have some defective deed or some document purporting title, then all you need is that enclosure on the property. If you are seeking adverse possession without color of title, meaning you don't have any deed or document, you are simply squatting on the property, then it's necessary that you've actually paid the taxes on the property. So with color of title is the enclosure, without color of title is the enclosure and the paying of taxes. Now, like I was saying, you can acquire title via adverse possession as a squatter, or you could do it more commonly, which is by acquiring a deed. And there are three types of deeds. There's general warranty deeds, special warranty deeds, and quitclaim deeds. You should, if you see a deed on an exam, then you should talk about deed formalities, the two subscribing witnesses, and the fact that it's in writing and adequately describes the property. And then you should also talk about the different types of deeds: general warranty deeds, special warranty deeds, and quitclaim deeds. General warranty deeds come with the 6 covenants: the present warranties and the future warranties. And we just came up with this cool mnemonic, SEC quiet football game, to remember the 6 covenants of a general warranty deed. And for those of you who don't understand why that's useful for some, because the SEC is a conference in college football and their football games are usually very loud. So it's kind of ironic, right? So SEC quiet football game, the present warranties are sizing, the right against encumbrances, and the right to convey. Right, so SEC, S for sizing, E for encumbrances, C for convey. The right of sizing, that you own the property, the right against encumbrances, that there's no mortgages or liens or anything on the property, and the right to convey the property, that you have the authority to transfer it. And then the future warranties are quiet enjoyment, further assurances, and general warranties, so quiet football game. And those warranties can be brought after the deed, but the present warranties of sizing, right against encumbrances, and right to convey need to be brought when the deed is being delivered. And in order for a deed to be delivered, there just needs to be the intent that it leaves the control of the transferor. So yeah, again, deed formalities and different types of deeds and the 6 covenants of a general warranty deed. These are all places we can get points on the essay. And like I said, real property, it's got to be in writing to conform with the statute of frauds. And then we could talk about potentially adverse possession if it's acquired in this hostile manner, right? These are some areas that we could potentially get points on a real property essay. Also, it's likely that it could be a simple landlord-tenant essay where you're just, writing about the different obligations that the landlord and the tenant may have, right? The landlord has to deliver the actual property and the legal right to possess the property, and then the landlord has to deliver, these duties of quiet enjoyment and habitability. Now, you might see quiet enjoyment as that was a warranty, a deed warranty, a future warranty of a general warranty deed, a future covenant, but it's also something that is implied in a landlord-tenant agreement. And there's different types of leases, right? And a good mnemonic is your period will suffer. A tenancy for years, a periodic tenancy, a tenancy at sufferance, and a tenancy at will and a tenancy at sufferance. So your period will suffer. Tenancy for years, periodic tenancy at will, and a tenancy at sufferance. A tenancy at sufferance is more or less a holdover tenant, and a tenancy at will is when you can, either party can end it at any time. A tenancy for years is for a set period of time, and if it's over a year, it must be in writing. And a periodic tenancy would be like a week-to-week or a month-to-month or something of that nature. And there's a deposit that must be paid back within 15 days or 30 days from giving notice of a dispute, and just different concepts like that you could get into with landlord-tenant issues. The tenant has the duty to pay rent, and the tenant has the duty not to commit waste. Now, a tenant in a landlord-tenant situation has the duty not to commit waste. So does a life estate tenant when we're dealing with life estates and remainderment and things of that nature. So waste, there are different types of waste. There's actual waste, which is also known as affirmative or voluntary waste, and that's like punching a hole in the property, like actually causing damage. There's permissive waste, which is like letting something rot or letting something deteriorate when you could have stopped it. You permitted it to become waste. And then there's ameliorative waste, which is like building an office building or building a rose garden on the property when you didn't have permission. Even if you increase the value of the property, you didn't have permission, and that would constitute waste. So, you can really look out for that landlord-tenant essay, and just remember the landlord has those duties of habitability, that it's like has running water and, proper access to sewage and things like that. And then and then quiet enjoyment, meaning that it's being free from outside use. The landlord's not walking in or the neighbors aren't walking in. So habitability and quiet enjoyment. Again, remember, quiet enjoyment comes twice as a warranty of a general warranty deed and as an implied warranty in a landlord-tenant contract. Quiet enjoyment comes twice. And then habitability also potentially comes twice as a warranty, an implied warranty of a landlord-tenant contract. And then only if it's a new sale, if it's a new construction. If it's a new construction, then the builder does warrant habitability and good workmanship. But, later down the line, subsequent sales of property don't really have that duty of habitability. But it's an interesting concept, and in Florida, when we're talking about the sale of residential real property, we think of Johnson v. Davis, a landmark case, which says that sellers of residential real property have a duty to disclose known defects or defects that they should have been aware of. So they're known as latent defects, right? Defects that the purchaser wouldn't have been able to find, but the seller knew or should have known about. You do have a duty to disclose in the sale of real property under Johnson v. Davis. There could be certainly an essay in Florida Real Property which is all about that, like a fraudulent misrepresentation or a concealment or some actionable claim where they induced the party to purchase land, but it was fraudulent or it was a misrepresentation or there was some concealment. And typically, the proper remedy for a breach of contract in real property would be specific performance, right? That's why I say that real property and contract law, bleed together, right? My legs, remember, land contracts are a type of contract, and that's what we're dealing with right here. And then, when we're talking about remedies, we're talking about specific performance, that they will be able to, require the purchase or sale of the property under the theory of specific performance. An interesting concept in real property is that the contract will merge with the deed. So contracts merge with the deed, meaning when the contract is signed by the parties, there's usually a period of due diligence after the signing of the contract, but before the closing. And during that period, under the theory of equitable conversion, which is recognized in Florida, the risk of loss will pass to the buyer. But once the deed is recorded, then the contract will merge into the deed, and you won't be able to bring any breach of contract claims. You'll have to bring these claims under the deed. And remember, the general warranty deed has the 6 covenants, SEC, quiet football games, sizen, right against encumbrances, the right to convey, and then the future warranties of quiet enjoyment, future or further assurances, and general warranties. And then a special warranty deed only provides warranties for the time in which the person possessed the property, the seller. It doesn't provide warranties for any upstream title. And then a quitclaim deed, they're only warranting that they're selling what they know they're selling, nothing more, nothing less, right? So a quitclaim deed is the worst type of deed that you could get. But these are some interesting concepts, right? Like merger and equitable conversion. And merger in real property actually has at least 2 meanings, one of them being the contract merges into the deed. And then another time we see merger is if a property owner merges 2 properties to exterminate an easement. And I'll talk about easements in just a little bit. So I know it's a lot on real property, and I'm trying to, keep it somehow organized in your minds. Remember, I started with just like the basics of real property that has to be in writing. We have deed formalities, and we have these, different discussions. Then we have the contract, and it could be like a misrepresentation or a concealment or some, failure of the duty to disclose, and that could lead to specific performance. We talk about the contract actually merging into the deed, the different types of deeds, general warranty deeds, and the 6 covenants. We talked about adverse possession and the way you could acquire if it's open, continuous, exclusive, adverse, notorious, hostile, and for the statutory period, which is 7 years in Florida. So these are some of the fundamental concepts we could see when we're dealing with a real property essay, right? And then the landlord-tenant thing, and if that's the duty the warranties of habitability and quiet enjoyment that the landlord owes, and then the tenant to pay rent and not commit waste. And waste would be actual, permissive, or ameliorative. There might be some like duty to repair, which could be split. It kind of depends on the case-by-case situation, but that's a pretty easy essay in my opinion. If it's a landlord-tenant situation, you just kind of talk about what's going on. If there's an eviction process. There's no self-help in Florida, so the tenant can't just come in and physically remove. The landlord can't just come in and physically remove the tenant. They would have to, have an eviction procedure. A retaliatory eviction would be a concept where the tenant has a proper case against the landlord and prevails, and then later the landlord evicts the tenant in retaliation, which is, not allowable. These are some key concepts. Okay, now going back to another route, like they could do, just that landlord-tenant, and they could do that blueprint in property, but they could also do a more complex one, which is really the conveyance, right? What type of property is it? Is it a fee simple absolute, meaning they just own the property, or is it a fee simple determinable? A fee simple, let's call it a fee simple defeasible, meaning it can be taken away or given to another party. So fee simple determinable has durational language to Tommy so long as it's used for educational purposes, right? If it's not used for educational purposes, the grantor will have that automatic right of reversion, where a fee simple subject to conditions subsequent means that, but if Tommy gets married to Tommy, but if Tommy gets married, then the grantor reserves the right to take back the property. That's known as the right of reentry. And then there's a fee simple subject to executory interest, and the executory interest could be a shifting or a springing executory interest. So a shifting executory interest would be like grantor to Tommy, but if Tommy gets married to Johnny, well, it'll shift from Tommy to Johnny. A springing executory interest would just be some event that springs from the grantor. Like Johnny owns the property, but if Tommy gets married, then it'll go to Tommy. So those are just some concepts of fee simples, fee simple to feasibles, which could be fee simple to terminable, durational language, fee simple subject to condition subsequent, which has conditional language and the right of reentry, and then fee simple subject to executory interest, which could be shifting grantee to a third party or springing grantor to a third party. So those are some concepts, right off the bat that are pretty difficult for a lot of students. And then we can think about like a mortgage on the property or some sort of notice question. So we got to understand lien theory and pure notice and dissect the mortgage. Well, first and foremost, Florida is a pure notice jurisdiction as opposed to a race jurisdiction or race notice jurisdiction. What a pure notice jurisdiction means is that bona fide purchasers will prevail. The subsequent bona fide purchaser, the last bona fide purchaser, the last person who takes the property for value in good faith and without notice will take free and clear of all prior interests. And then any person who takes after that BFP will be able to seek shelter in the upstream status of the BFP, right? Once the BFP comes in, they will cut off all interest above them. So the key understanding there, and what you must discuss in the essay, is the concept of what is a bona fide purchaser, someone who takes without notice for good faith and with good faith and for value, and without notice. There's different types of notice. Actual notice, meaning like if it's an easement question, the person actually knew that there was an easement. They saw it. They were aware. That's actual notice. There's constructive notice, which could be record notice, like it's recorded. So they had they're ascribed with knowledge because it was in the records, right? That's record notice. And then there's inquiry notice. Inquiry notice means a reasonable inspection of the property would have put them on notice. Like if someone's operating a farm on the property, then you will be, again, ascribed with notice that they were operating a farm. You should have visited the farm and you should have seen it. So that's the concept there with Florida's a pure notice jurisdiction. We're looking to protect the bona fide purchaser. The bona fide purchaser is the one that takes for value in good faith without notice, and notice can be actual, inquiry, or record, and these are important concepts to discuss. And then for value, meaning that they pay money for the property, they're not gifted it. But if they, Tommy pays money and has no notice and it's in good faith, and then he's a bona fide purchaser and takes the property, that will cut off any earlier interest, and then he gifts it to Johnny. Well, even though Johnny didn't pay for it, Johnny's still going to be able to take upstream shelter in the status of the bona fide purchaser. So that's the concept of a pure notice jurisdiction. And then Florida is also a lien theory state as opposed to a title theory state. The main implication of a lien theory state is that a lien or a mortgage on a property, let's say a mortgage on a property, will not sever a JTROS. So taking a step back, there's three different types of tenancies, of joint tenancies. There's joint tenancy with the right of survivorship, there's tenancy by the entirety, and there's tenancy in common. We assume a tenancy in common where A and B take this tenancy, and if B dies, B's heirs will take B's interest, right? That's a tenancy in common. A JTROS means A and B are joint tenants, and if B dies, A will survive B and take the entirety, right? Like that's a JTROS. And then a tenancy by the entirety is a JTROS plus marriage. And a JTROS, a joint tenancy with the right of survivorship, requires the four unities of time, title, interest, and possession, right? So if A and B are joint tenants with the right of survivorship, and A takes a mortgage on the property, that will not sever the JTROS, meaning the bank will only have a lien on the property. They won't have title to the property. So in that situation, if A were to die, the bank could not collect from B on the property because the lien is extinguished from the property upon death. It's not going to sever the JTROS and give them title to the property. It also means that, it won't sever the JTROS, and it will not be possible if that party it dies to collect from the property itself. So we understand pure notice jurisdiction and lien theory state, and we understand the different types of tenancies, tenancy in common, JTROS, and tenancy by the entirety. An important concept is the concept of mortgages. So what is a mortgage? A mortgage is a loan secured by property. So a mortgage is like the mortgage note and then the mortgage security agreement. The note is like the promise to pay back principal plus interest, and the security agreement means, and if you don't pay back that money, then we're going to be able to foreclose on the house. So in that situation, the mortgagor is the borrower, the mortgagee is the lender, and a foreclosure is the forced sale of the property upon non-payment. There could be a senior mortgagor a senior mortgagee and junior mortgagees, meaning like senior and junior lenders. It's usually first in time, first in right. Whoever takes the first mortgage on the property will have, the first and records it. Let's say will have the highest interest, unless there was known as a purchase money mortgage. And a purchase money mortgage means that the actual money that's borrowed is used to purchase the property itself. They will have first priority. Even if they're second in time or third in time, they'll have a super priority. So that's the purchase money mortgage conversation, senior mortgagees and junior mortgagees. In the event of, again, non-payment, they could seek a foreclosure action, which is the forced sale of the property, and the proceeds will go to pay off the senior mortgagee, and then all the junior mortgagees, as long as they're notified, their interest will be terminated from the property. And if the junior mortgagees, or let's say the senior mortgagee, if there's not enough to pay them, need to collect, they'll have to seek a deficiency judgment against the mortgagor. So those are some key terms like foreclosure action, deficiency judgment, purchase money mortgage. Also, some concepts you can look for are like a due on sale clause. Like if the property is sold, the entire mortgage is due. That's usually valid and enforceable if it's reasonable. A no early prepayment clause, which could be, valid and enforceable, or, fees for early prepayment, things of that nature could all be valid and enforceable if they're agreed upon. Or like an equitable mortgage, meaning a mortgage that was not recorded but still operates as a mortgage. The court will probably enforce it as a mortgage. And what a mortgage means is a loan secured by property, and in the event of non-payment, the lender could potentially seek a foreclosure action, which is the forced sale of the property, and the proceeds will go to pay back the lenders. There's an equitable right of redemption, which means if the mortgagor comes back with the money before the sale of the property, after foreclosure proceedings have begun, they could buy the property. Or potentially a statutory right of redemption, which, is not really tested in Florida, which means they could potentially buy back the property after the foreclosure sale if the jurisdiction provided for it. So really make sure you understand mortgages, pure notice jurisdiction, lien theory state. These are some definitely interesting and testable topics. Otherwise, easements is important to understand. There's different types of easements, and I think of it as having like, two ends of the spectrum, and there's, three spectrums. The first is negative versus affirmative, right? A negative easement is like a restriction on light or air or water, which they're not really enforceable, right? The Fountain Blue versus Eden Rock case kind of informed us there's no right to a view in Florida to light or air, but there are riparian rights. Your neighbor can't restrict your reasonable use of the water, or your prior use of the water, or your reasonable flow of the water. Those would be negative easements. An affirmative easement would be like, a right to cross over your neighbor's property or something like that. So there's negative and affirmative. There's express and implied. And express and implied are like express is in writing, and implied would be some sort of prior use or implication would create an easement. Then there are easement by prescriptions and easement by necessity. So an easement by prescription is very similar to adverse possession. It's like you did it, it was open, continuous, adverse, notorious, hostile, and for the statutory period of 20 years in Florida. Notice that it doesn't need to be exclusive because multiple people could have the same prescriptive easement. And then easement by necessity, it could be statutory or common law where a property is hemmed in and has no access to a public road. Then it would require an easement by necessity. And then there's easement appurtenance and easement engross. Easement appurtenance, it run with the land, and that's when, it's neighboring properties and there's an easement over the land. And then easement engross are personal, and it would be like a utility company that has an easement on the property. So, those are actually, there's 4 spectrums. Affirmative and negative, express and implied, appurtenant and engross, and by prescription and by necessity. And if you can just talk about those easements and all the elements, that should really help you do pretty well on the exam. Another topic that could be tested would be a real covenant or an equitable servitude. Real covenants and equitable servitudes are promises to do or to not do something on a property. Like in my townhouse development, we all have to paint our doors blue, and that's an equitable servitude because it's remedied by injunction. So equitable servitudes are remedied by injunction, and real covenants are remedied by monetary relief. So look out for that. And for them to run with the land, there has to be notice, intent. It needs to touch and concern the land. Real covenants need to be in writing, and there should be some, evidence of privity, whether it's horizontal amongst the original parties or vertical amongst subsequent parties. But in general, real covenants are more difficult to run with the land than equitable servitudes, but the elements have been relaxed in most jurisdictions. Just know that they're promises that are tied to the land. So, we talked about easements, adverse possession, equitable servitudes, real covenants, mortgages. These are some difficult concepts that are definitely important to know, and I definitely wanted to go over them today. I still have a few minutes for sure, and there's definitely more things that I need to talk about. Just give me a second here. So when you're talking about real property, maybe you could think about a partition, and a partition is when joint tenants decide to split up the property, either a judicial partition, which would be the sale of the property, or a actual physical partition, which would be a divide of the property. Remember, remainder men cannot seek partitions. They have to wait until their property actually, their rights actually vest. They actually receive the property. Life estate tenants, like we said, if you're to Tommy for life and then to Johnny, Johnny's the remainder man, Tommy is the life estate tenant. Tommy cannot commit waste, and Tommy has to pay taxes on the property and the living expenses, and then the remainder man will pay the principal of the actual mortgage. If you see some conveyance and you think, oh, maybe this implicates the rule against perpetuities, very rare, but you could just drop it and get some points, I guess. No interest in land is valid unless it must vest, if at all, within 21 years of the death of a life and being at the time the interest was created, meaning that, if there's some, executory interest or, remainder that's subject to open or subject to total divestment or a contingent remainder, and it could potentially outlast the last living person and either, be unclear if it's going to vest or not for too long, be in limbo, then that could potentially violate the rule against perpetuities. But again, I don't think that's too likely to be tested. Zoning laws, right? You should understand amortization, variance, and a nonconforming use. And amortization means that, well, let me step back with the nonconforming use. Nonconforming use means you're doing something different, like you were doing commercial, and then it got rezoned for residential. Well, you're allowed to continue doing commercial. You're grandfathered in. So nonconforming use means you're grandfathered in, and you're allowed to continue doing the use that you were doing earlier. And amortization means you're going to slowly conform that use over time. And then a variance just means you're applying for a permit to do something totally different. So a variance is applying for a permit to do something different than you're zoned for. A nonconforming use means you're going to be grandfathered in and be allowed to continue doing it. And then an amortization means that you'll slowly conform that use over time. Honestly, I feel like we crushed it with real property. I know it's a really difficult subject. I was trying to at least go 30 minutes with the sand. with the sand clock right here, the hourglass, and I think I did. Thinking back, are there any other subjects in real property? I mean, takings, which could implicate the Fifth Amendment. They have to provide just compensation if there's a governmental takings. The homestead exemption, where in Florida, your home is protected a half acre inside a property and 160 contiguous acres outside of a property. Real property can blend into a lot of other subjects, whether it be family law because of the homestead and the protection of the spouse and the minor children, contracts because remember my legs, land sale contract and the contract merging into the deed, and then constitutional law because of elements like zoning with the variance, nonconforming use, and the amortization, and the takings with the Fifth Amendment and maybe like a condemnation where the government is condemning your property. They still have to provide just compensation. So real property questions can be really, really tough, but you just want to approach it, very broadly, starting from the top about how it has to be in writing, what the elements are of the deed, what are the deed formalities, whether it was acquired via adverse possession or whether it was acquired properly. One last thing I'll mention is that in every land sale contract, there's the implied warranty of marketability, which means that the piece of land is free from encumbrances, there's no mortgages, there's no easements, there's no liens, there's no threats of litigation, no weird zoning ordinances, it's not subject to a defeasible fee condition, it wasn't acquired by adverse possession, or there's no what's known as a right of first refusal, meaning like A sells to B, but if B ever wants to sell it, A gets the right to buy it back first. Anything like that, some weird condition would make it not marketable. Now, you can waive marketable title, but just remember that is implied in every land sale contract. So, I think today was a pretty solid, overview of some of the general points of real property. Really make sure you understand how a mortgage works, that a mortgage is a loan secured by property. In the event of non-payment, there can be a foreclosure. And if the foreclosure sale is not enough, then the junior mortgagees will need to seek a deficiency action. Another word that I like is a surcharge, and this comes with the overuse of an easement. If someone overuses an easement, it's not going to necessarily lead to the termination of the easement. It would most likely lead to injunctive relief and a surcharge for that use. So, a lot we could talk about with real property, but I hope this lecture was helpful. I'll be back doing lectures for every subject on the Florida Bar. My name is Andrew with Ibis Prep, and it's been an absolute pleasure today. Thank you so much.